Hi students, the next chapter in business law is classification of contracts. In the previous chapter we have seen about what is a contract, meaning, definition, essentials, etc. Now the next chapter is classification of contracts. Classification is nothing but the types of contract or kinds of contracts. What are the various types of contracts? Contracts can be classified into three types or three bases we can classify the contracts. Number one is on the basis of validity. Number two is on the basis of formation. Number three is on the basis of performance. Now we will see about the types of contracts on various bases. First, number one, on the basis of validity. What is validity? Validity means the contract enforceability. It is called as validity. Validity is nothing but enforceability. Enforceability means that whether the contract can be enforced or not. That is called as enforceability. Whether the contract is valid or not, it is called as enforceability. Based on enforceability, we can divide the contracts into five types. Number one is valid contract. Valid contract. What is a valid contract? It is a contract in which all the essentials of contract were present. Essentials of contract were offer, acceptance, legal relationship. That is essentials of contract. If all the essentials are present, then it is called as valid contract, which is enforceable by court of law. Second one is void contract or void agreement. A contract which cannot be enforced by law, then it is called as a void contract. Next, third one is voidable contract. Voidable contract is an agreement or a contract which is enforceable at the option of one or more parties, but not at the option of other or others. Then it is called as a voidable contract. In this type of contract, the consent of one party will not be free. The consent of the other party, that is the acceptance given by the other party, is received by way of fraud or something. That is called as voidable contract. Then next one is illegal agreements. Illegal is the agreements are not enforceable by law because the object or the subject matter or the purpose for which the agreement is formed, which is illegal. The last one in case of validity is unenforceable contract. This is a contract which is not enforceable by law because the legal formalities, that is essential of contract legal formalities, were not fulfilled. These are the five contracts on the basis of validity. Number one is valid contract, which is enforceable by law. Void contract, which is not enforceable by law. Third one is voidable contract. It is also not enforceable by law at the option of one party and not at the option of other. Next, illegal agreement, which is also not enforceable by law because the object or the purpose for which the agreement entered, it is illegal. The last one is unenforceable contract. It is also a contract which is not enforceable because the legal formalities relating to the contract were not fulfilled. This is regarding classification of contract on the basis of validity. The next classification of contract is on the basis of formation. What is formation? Formation means creation of contract. How a contract is formed, that is called as formation. On the basis of formation, we can divide the contract into three types. Number one is express contract. Number two is implied contract. And number three is e-commerce contract. These are the three types of contracts. Number one, express contract. What is the express contract? It is a contract formed by words spoken or written. It is a contract created by the words spoken or written. It is called as express contract. It is expressed by the words spoken or written. Next one is implied contract. Implied contract. What is an implied contract? It is a contract not formed by words spoken or written. It is implied by the conduct of the parties. The behavior of the parties will make a contract. That is called as implied contract. We can divide the implied contract into two types. Number one is quasi contract and number two is tacit contract. What is a quasi contract? In this contract, there will be no contract formed by words spoken or written. That is, a contract is formed on the basis of situation. For example, if a person has met with an accident, then some other person going in the street, they are helping him. Then it is like a contract. No offer, no acceptance. It is not created by words spoken or written. It is implied by the conduct of the parties. It is a situation. Based on the situation, we are helping others. For that, a contract will be formed. That is called as quasi-contract. Next one is tacit contract. What is a tacit contract? It is a contract inferred from the conduct of the parties. Everyone is doing a thing. The others will also do, and everyone will also do the same thing. That is, if you are entering into a bus, you want to buy tickets, then it is called as a tacit contract. If you are entering into a hotel, you want to pay for what you have ate. That is called as a tacit contract. This is regarding implied contract. We are having two types of implied contract. Next, third one is e-commerce contract. These contracts are famous nowadays. The buying and selling the goods through online shopping. That is the best example for e-commerce contracts. These are the contracts formed through internet. This is called as the contracts classified on the basis of formation or creation. This is contracts on the basis of formation. The next type of contract or the next classification of contract is on the basis of performance. What is performance? Performance is doing a particular thing, fulfillment of the duty in the contract, fulfillment of the obligation in the contract. That is, doing a work in the contract is called as performance. On the basis of performance, we can divide the contract into four types. Number one is executed contract. What is executed contract? The parties to the contract fulfilled their obligations. That is, two parties A and B, they agreed to sell the house. A agreed to sell his house to B for rupees 10 lakhs. If A has sold his house and B has paid 10 lakhs, then it is called as executed contract. Next one is executory contract. Executory contract is if either of the parties have not fulfilled the obligation. If A or B, anyone has not done the things, or both have not done the work, then it is called as executory contract. Next one is unilateral contract. What is unilateral contract? If the obligation of one party is outstanding. For example, A has not sold his house to B, B is ready to pay rupees 10 lakhs. Then it is called as unilateral contract. Next one is bilateral contract. Bilateral contract is both the parties' obligations were outstanding. Then it is called as bilateral contract. A is not ready to sell his house now and B is not ready to pay now. But in future they are going to do. Both the parties' obligations were outstanding. Then it is called as bilateral contract. These are the various types of contracts on the basis of performance. So the contracts can be classified on the three bases. One is on the basis of enforceability. Next one is on the basis of formation. Then the third one is on the basis of performance. These are the types of contract. Next aspect in classification of contract is the differences between various types of contracts. Number one is differences between void contract and voidable contract. Void contract, it is a contract not enforced by law. Voidable contract is contract not enforceable at the option of affected party. Second difference is a void contract cannot be changed into valid contract. In case of voidable contract, a voidable contract can be changed into valid contract and at the desire of the affected party. That is, void contract cannot be changed into valid contract, whereas voidable contract, because voidable contract is a contract in which the consent is not free. If the consent of the party is free, if you can make the consent of the party free, then you can change the voidable contract into a valid contract. Then the third difference is the contract become void on account of specific violation of the statute. The contracts become void on account of the specific violation of the statute is if you are not following or fulfilling the rules and regulations, then the contract will become void. Then in case of voidable, the contract become voidable on account of absence of free consent. That is, void contract, it will become void on if you are not following any one of the essentials of a contract, whereas voidable contract will become voidable if there is no free consent. If the essential free consent is not present, then it is a voidable contract. Then the fourth difference is the void contract is not enforceable because of the absence of any essential or valid contract such as offer, acceptance, legal relationship. The same thing I have explained the last difference also. That is, the void contract is not enforceable. Why? Because the essential of a valid contract, any one essential is not present, then it is a void contract. Whereas voidable contract is not enforceable at the option of one party because the consent is obtained through coercion, fraud, etc. That is, the voidable contract is not enforceable at the option of one party because the consent of the contract, that is, the consent is not free. Free means if the consent is obtained through force, then it is called as a voidable contract. This is regarding the differences between void contract and voidable contract. The next one is the differences between void agreement and void contract. What is a void agreement? An agreement not enforceable by law, then it is called a void agreement. Void contract, a contract which ceases to be enforceable by law becomes void. A contract has been formed, after formation it is not enforceable, then it becomes voidable. Whereas agreement, before forming a contract itself, it is not enforceable, so it is a void agreement. Second one is it is void from the very beginning. Void agreement is one which is void at the beginning of the agreement itself, whereas void contract, it is valid in the beginning and becomes void subsequently due to the changes in the circumstances. That is, void agreement at the beginning itself it is void, whereas void contract at the beginning it is valid, after that it becomes void. Next, third one is an agreement becomes void due to the absence of one or more essentials of the valid contract, whereas void contract, it becomes void due to impossibility to perform. So void agreement is an agreement becomes void because any one essential is not present in case of a valid contract, whereas void contract, it becomes void due to impossibility to perform. First it is possible to perform, afterwards it becomes impossible, so it becomes void. This is regarding the differences between void agreement and void contract. The important questions in case of this chapter is, in 10 mark they will be asking what are the various types of contract or classification of contract. In case of 5 mark they will ask any one differences regarding the types of contract, that is void and voidable, or void agreement and void contract. This is regarding the important questions in this chapter. If you are interested in my videos, if you like my videos, you like, you give a comment, you give your valuable suggestions, you share my videos to other students, then if you are very much interested, you can subscribe to my channel by pressing the bell icon in the front. Thank you.